How to circumvent the procedural obstacles of the European Union to secure the fishing rights of the EU members in the archipelago of Svalbard. The conflicting interpretations as to the territorial scope of the 1920 Treaty of Paris have sparked some tensions between several EU member states and Norway over the fishing rights to catch snow crabs in the Svalbard archipelago. The directly affected EU member states have failed in their attempt to channel their disgruntlement through the EU institutions against Norway's violations of the Treaty of Paris. So a change in their legal strategy is required. EU member states, instead of undertaking legal actions against Norway through the EU, may take direct international legal actions by using the bilateral international instruments they entered into with Norway. EU's failure to take a strong stance. In 2016, a Lithuanian trawler holding an EU license to catch snow crab in Svalbard waters was seized by the Norwegian Coast Guard and fined by Norway's Supreme Court because it did not possess a Norwegian license. This again happened the following year in 2017 to a Latvian trawler. Consequently, most of EU's trawlers have been deterred from catching snow crabs and so remained docked at their harbors while unobstructed Norwegian snow crabs trawlers are flourishing. On December 22, 2017, the Republic of Latvia sent to the EU Commission an expressed invitation to act in defense of EU fishing rights within a predetermined period of time. However, the EU Commission failed to take a strong stance on this issue. So on May 10, 2018, Latvia submitted an application to the Court of Justice of the European Union against the EU Commission pursuant to Article 263 of the Treaty on the Functioning of the European Union for failing to act under Article 265 of the same treaty. Namely, Latvia complained that the EU Commission did not arrange official negotiations with Norway, nor it brought international judicial proceedings against Norway, as requested by Latvia, with the aim of securing EU's fishing rights within the predetermined time period. On June 27, 2018, also the EU Parliament manifested its concerns for the EU vessel owners who had invested heavily in snow crab business based on the EU legislation and the Treaty of Paris, and are now prevented from fishing in Svalbard by the Norwegian authorities despite holding valid EU licenses. Therefore, the EU Parliament demanded from the EU Commission a solution to safeguard the legitimate rights of the EU vessels and member states. On August 16, 2018, also, the Kingdom of Spain applied for leave to intervene in support of Latvia in the action against the EU Commission before the Court of Justice of the EU. The EU Commission replied to Latvia by stating that it would continue to participate in the negotiations with Norway without fixing a final date for the end of those negotiations, and that procedural obstacles were in the way for allowing the EU to bring international judicial proceedings against Norway. The EU Commission specified these procedural impediments. Firstly, the Treaty of Paris does not provide for a dispute settlement mechanism, and the dispute settlement mechanisms provided for by the United Nations Convention on the Law of the Sea are not applicable, since the issue at hand is not about the interpretation and application of the UN Convention on the Law of the Sea, but rather about the interpretation and application of the Treaty of Paris. Secondly, international arbitration is subject to finding an agreement with Norway, which is currently highly unlikely in the prevailing circumstances. Thirdly, the default dispute settlement mechanism that remains in the International Court of Justice, however, the EU has no legal standing before the ICJ. Fourthly, while a number of EU member states are party to the 1920 Treaty of Paris, the EU is not. On January 30, 2020, the Court of Justice of the EU issued an order declaring Latvia's application inadmissible as the EU Commission is not obliged to act upon a request made by a member state, nor it would have been able to do so in light of the procedural obstacles. Possible instruments to solve the diplomatic stalemate. While the EU may be facing procedural obstacles to bring international judicial proceedings against Norway, the affected EU member states may rely on bilateral instruments to circumvent such obstacles and bring international judicial proceedings directly against Norway. Among the EU states that have issued snow crabs catching licenses with the prior authorization of the EU Commission and that are a party to the Treaty of Paris, Norway has bilateral investment treaties with 4 of them: Estonia, Lithuania, Latvia, and Poland. All 4 bilateral investment treaties impose on Norway certain international obligations, specifically applicable also to the continental shelf over which Norway exercises. In accordance with international law, sovereign rights for the purpose of exploration and exploitation of natural resources. Pursuant to these obligations, Norway shall accord fair and equitable treatment and the most favored nation's treatment to the other state parties' investors and shall compensate in case of expropriation. Arguably, Norway breached all these obligations toward EU snow crabs trawlers in Svalbard. by implementing a creeping nationality-oriented jurisdiction over Svalbard waters, which ultimately resulted into a creeping expropriation of the licenses of the EU trawlers. Among the remedies available for Norway's violations of its bilateral investment treaties is the launching of the state-to-state arbitration. So these EU member states may leverage Norway's consent to arbitrate an investment dispute contained in these BITs to file an international arbitration against Norway with the aim of securing the fishing rights of their respective national investors as a form of diplomatic protection. Spain is also a party to the Treaty of Paris, but it does not have a bilateral investment treaty with Norway. Nevertheless, in 1929, Spain and Norway entered into a treaty on conciliation, judicial settlement, and arbitration. Such bilateral instrument provides for a general compromissory clause to settle future disputes between the contracting parties by way of arbitration. Therefore, also Spain may threaten recourse to an international arbitration by invoking this 1929 instrument against Norway and thus protecting its fishing rights stemming from the 1920 Treaty of Paris. Conclusion. Arbitral tribunals established under Norway's bilateral investment treaties and the Spain-Norway Treaty on Conciliation, Judicial Settlement, and Arbitration may determine the width of the territorial scope of the Treaty of Paris, thus putting an end to the contentious issue. An international, independent, and neutral adjudicator may indeed solve this issue by determining whether the Treaty of Paris shall apply either up to the 12 nautical miles from the baseline of the archipelago, as maintained by Norway, or up to the 200 nautical miles of the economic zone, as contended by the EU. Such finding, in the form of enforceable and binding arbitral awards, may provide the affected EU member states with the effective solution they're looking for against Norway's discriminatory and expropriatory measures. Bottega di Bella. Empowering your international rights.